So my question is, well, where is the South African industry? Where does the panel perhaps see this thing? Are we finding that there are almost a knee-jerk reaction of rejection of adjudicated decisions, and we have to go to court? There are what seem to be long delays before we can get our summary judgments, at least 8 months. So perhaps you'd like to kick off there.
It's very difficult to give a general picture. The problem that we have in our country at the moment, as I see it, is that people are still all too keen to jump on the bandwagon of taking an adjudicator to court and resisting paying the award, even if it's on an interim basis. And they will find any excuse to do this. They will find any excuse to delay payment. And as you say, one of the major difficulties we have is that depending upon the judge who the matter comes before, you might find a decision delayed by 6, 7, 8 months, 9 months more. One of the major problems we have at the moment are complaints to various judges, President, around the country about judgments that are delayed, promises to do something about it, but nothing much terribly much seems to happen. And then even when the decision comes out, that's not the end of the matter, because there's an immediate application for leave to appeal, and the judge of first instance is asked to put some sort of mechanism in place to delay payment, and they scratch their heads and they wonder, well, should we do this, shouldn't we do this, are we going to do this? So it remains problematic. Hopefully it will sort out in time to come, but it is problematic and remains so. And Bob, you'll obviously have seen this time and time again in sitting where you sit.
Yeah, there were 2 points that I just wanted to make. May I speak without this? If you can't hear me, please tell me, but I generally don't speak with these things, and they say I've got a loud voice, and if you can't hear me, tell me and I'll use the thing. But one point that Robert made, and I think one must just be careful of this, he suggested that before you start this process, you need a statute in place. We're very lucky in this country in that we follow on other countries. We are generally lag behind. You don't need a statute in this country. And the reason for that, provided you've got your contract and the JBCC contract has got it all, that reflects largely what the English principles are. And the courts in this country will follow English decisions. They already have, as you've said. And there's only one case that has come to the appeal court. And in that case, we made a point of endorsing, as it were, the principles, even though it wasn't directly in point. So you already have a sound framework. And you shouldn't think, well, let's wait for a statute to come before we proceed. You've got the contract, it's got everything in it, and you've already got a court system. You're quite right. My bread and butter has come from the courts. I mean, the courts have put bread and butter on my table, so it might be odd that I say this. And I say, avoid the courts as far as you can. And I won't go into why. And it's always been the case. Courts are a law unto themselves. That's the problem. They decide, and you've got no power over them. Adjudicators, arbitrators, you do have some power of them because you're paying them. So that's, one wants to try and avoid courts. Adjudication, to me, it's absolutely clear that it is going to be advantageous to the industry. Absolutely clear. On one condition, and that was raised by I don't know who, it depends who your adjudicators are. And your adjudicators must be people who are not only skilled in the field, but sussed enough to know how to avoid courts setting aside their decisions. Take, for example, this fundamental thing, natural justice. I don't know how many times I've had cases before me where a government official or someone in some position of decision-making capacity has said, has been taken on the basis, look, you didn't give me a hearing. And the person says, well, I didn't have to, and he contests it. And I've said to them time and time again, but why didn't you give him a hearing? Doesn't matter if you had to or not. He might have something to say that's valuable, and there's no downside, so why didn't you? Our adjudicators who are sussed will realize that those are the areas they can be taken on review on, like jurisdiction, natural justice, things like that. And they can, if they're sussed enough, cut down the opportunity for cases to go to court. It depends on your adjudicators, and you must be very careful that you choose adjudicators who are not, with respect, only engineers. But engineers, if you want engineers who understand how the courts work and understand the gaps that they've got to fill.
Thank you. And I think that was going to be my next question, and say, well, do we think that perhaps one of the reasons why so many of the decisions are being rejected by one or other parties, in some instances both parties, is because of the quality of the decision made by the adjudicator? Is that a possibility?
Look, I think that South African businnesmen, I don't know how they're in England, they tend to be a fairly rough lot. And, they prefer not to pay if they can avoid paying. I mean, I suppose that's quite common, and I'm sure you all encountered that. So, but the point is that you've got to be in a position where you give them as little scope as possible to maneuver. And you can't stop the businessmen, the contractors, employers, or whatever, who are going to try and avoid paying. But what you can do is cut down the opportunity for them to get to a court. And that depends on your adjudicators. It's as simple as that.
And I think another factor, Ian, is getting the industry to buy into adjudication. I was just talking to Robert before we started. I touched on commercial mediation and told him how slow we are to embrace commercial mediation in this country. There are various courses offered in this country that are modeled on the English courses, and there are various institutions to which you can become accredited. Commercial mediation should be a reality in every commercial dispute. But what we find in this country is that the litigation attorneys, faced with the possibility that after a one-day mediation a dispute is going to go away, tend to resist it, and they tend to resist it on the basis, well, where the hell are we going to get our fees from? Here's a case out of which we'd have made millions of rands in fees. It's a big commercial dispute. It's a dispute that's going to go all the way to the appeal court, and perhaps in today's world where everybody finds a constitutional issue about everything, it'll go to the constitutional court. And what's going to happen if we have a one-day, two-day mediation and the matter settles in part, or it settles in toto, or perhaps people go away and think about it and come back a month later and they do settle? We've lost that huge amount that we would have earned out of the litigation. And so my experience since I've been doing commercial mediations is that as often as not, when the client comes to a mediation with a litigation attorney, you find the litigation attorney being positively obstructive. And mediation becomes much more difficult in these circumstances where it should be encouraged and facilitated. And I think that until the industry has a mind shift, certainly on mediation, and I would believe the same on adjudication and the powers and the scope of a DAB's board's discretion and jurisdiction, until you get a buy-in, it's difficult, and the difficult thing is going to be to get the industry to buy in.
Yeah, I think. Sorry.
Perhaps I could say a little about the UK experience of mediation in construction. I do a fair bit of mediation and have done. I was CEDA accredited 1999, so I've been doing it 15 years. When I started, there was very little take-up of construction mediation, but it's grown steadily as people see that it works. And it has the most amazing success rate. 80% of construction mediations settle either on the day or then 2 or 3 days after that. And nowadays, you can say that virtually every big construction case in the UK will at some point go to mediation. Now, picking up your point, is that because all the solicitors, because that's what attorneys are in the UK, are all these solicitors magnanimous and they're doing it even though it's going to cut their own throats? Absolutely not. They're doing it for sound commercial reasons, because what has happened is that as people see that mediation is a way of getting a quick, cheap decision and settlement, they all come into the market when prior to mediation, they stayed out of the market. So that, for example, you get fairly careful contractors who think, I've never had anything to do with the courts or arbitration and so on. But they've got a gripe, and they appreciate, from having heard from friends at conferences and so on, that you can get a decision in mediation or get a compromise in 80% of the cases. And so they come into the field. They come and have it mediated. And then they get to know the lawyers, and when they have another problem, they come back to the lawyers, and some will settle in mediation, 20% won't. But a huge number of people who were never ever going to raise a dispute for one reason or another now are in the field raising disputes, hoping that most of them will get settled by mediation, but many of them don't, 20% don't. That's quite a lot if you've got a big catchment area. And so I mentioned, again, my own personal experience. We in Keating Chambers do a huge amount of mediation, and we've been growing year on year, every year for the 35, 36 years I've been there. And that tells you that the work does not dry up. Far from it. Bad news for all you contractors, but great news for you lawyers. Mediation actually helps lawyers because it introduces people who wouldn't ever have disputed otherwise into the field. And they like what they see, and they get to know the lawyers, and on they go. So mediation's great. And in fact, I was talking to someone outside who is a mediator in the construction industry. Louise, where are you? But anyway, I know maybe she probably got so fed up with the first part, she's headed off. But she was telling me she mediates in the construction industry, and there are people doing it, and it's a good thing.
Thanks, Robert.
May I just pick up on something, because I've heard this a number of times, and I don't want to take the floor, but, you know, there's been a lot of suggestion that, you know, lawyers are going to make a lot of money out of this. Well, you're all contractors, and I'm sure you don't really like the idea of lawyers making a lot of money. But I want to put another thing to you, which I was interested to see that Robert, in fact, the statistics in England show it, because it seemed to me obvious that it would occur. Now, let me just give you a bit of preface that was saying. Until 6 months ago, for the last 20 years, I've been in the courts, so I haven't been in the arbitration field. And the last 15 years have been in the appeal court, which is even more remote. But I do recall when I was at the bar, those long arbitrations, maybe some of you were in them, they occurred because your problems developed throughout this contract, and you had a big file of them, and they all had to be resolved. And you'll remember those cases in which you'd start from, when you're building a tunnel, you'd start from point one and go meter by meter through this tunnel. And the lawyers would be there, and it would go on for a year. And when you'd got to 10 meters, you all gave up because this is just too much. I believe you're going to avoid a lot of that arbitration. That is where you contractors and employers and subcontractors are going to score, in that they're not going to have those long arbitrations. And the reason for that is a simple one to me. And you take this from all disputes of any kind that I've seen. Businessmen generally want certainty. If they get certainty, they can move on. And if you have adjudication, as it arises, number one, it's hot. Secondly, you get a decision. You might think it's wrong. You might think I'll contest it in arbitration. By the time this contract is finished, you'll probably forget about it. And you'll forget about it because you've adjusted your affairs to account for this decision, or there's been swings and roundabouts or whatever. But most of these adjudication decisions that you think are wrong are going to become largely irrelevant at the end. And I predict that that arbitration will reduce, and especially these endless arbitrations will reduce dramatically. And I think that you said the figures show that. We don't have the statistics yet to say that, but it seems to me to be obvious that that's going to happen. So you'll cut out the lawyers at that stage, those long arbitrations.
Yeah, I think that is so. Now, I want to pick up on a point which Guy was making earlier, saying the industry must get their head around this and accept that this is the way to go. The problem we have, as I see it anyway, is that very often when a contractor finds himself in that predicament at the beginning of that tunnel, and he's staring at a major loss, and he now realizes he has to go the claim route. And he now trundles down to his attorney, and what does the attorney tell him? Don't go to adjudication, because it's not final and binding. We want to go to arbitration. So he accepts that. So we don't just need to educate the construction industry, also need to educate the lawyers, and pick up on your point that the lawyers aren't going to lose out. They're going to have a different role, and a more effective role, and add value rather than cost. That's what it's about, isn't it? Yeah. So how do we address that?
Well, you'd have to talk to Vaughan on this. I'm talking about mediation in the construction industry tomorrow at MDA's offices with Vaughan, I think to some staff. But if you talk to Vaughan and he's happy to invite you, I'm happy to talk to anyone who wants to know my views on mediation in the construction industry. But it does work, I can tell you. Very effective, very cheap.
Yeah, I'm really talking about the adoption of adjudication and buying into adjudication. And I think a lot of that comes back to one of your earlier points, that is that we need competent adjudicators. And if you look at the panels that are available, I think there's 9 on the NEC, there's perhaps 15 under the SAICE, the CIDB panel, which they established about 2 years ago, is now defunct. They don't use it anymore. And most of the other panels are, in my opinion, with the greatest of respect, retreaded arbitrators or mediators, and it's not the same process.
I think it's a matter of education. I mean, this sort of a session is great because you're hearing a lot of views. You are talking amongst yourselves outside, I know, hopefully not inside as well. And so you're getting an aspect of adjudication which you might not have come across before. But the fact is, it does totally overturn all the preconceptions, certainly overturn mine, and it game changes. The construction industry won't be the same after widespread adjudication comes in as it was before, and all for the good.
Yeah, I think that's so. Just to change the attack a little bit here, and just try and set the scene for where we might be going as an industry. Do we perhaps think that we're in a very special set of circumstances at the moment, and that with a turnaround in the economies in the developed world, that our economy will turn around, that the need for disputes and dispute resolution will evaporate, and we'll go back to the good old days where everything was resolved with a shake of hand over a beer on the bar on Friday? Or are we in reality now experiencing what we're going to have forever?
There will only be more disputes worldwide. I can give you a few statistics there. The GNP in most countries with mature economies has about 10% for the construction industry. For developing economies, it's higher than that. So 10% is about the lowest you get. The appointing bodies who are appointing international arbitrators in every conceivable field, financial, shipping, and so on, they find that between 15, 16 to 20% of all their cases are construction engineering. As we get more and more globalization, and that's definitely the trend of the future, you get more and more international construction projects done by more and more different players. In my experience now, if you get a really big construction project, there's a consortium, and they come from all over the place. So you'll get, I gave you an example, Swiss and Americans. That's not unusual. I've just done a Kazakhstani case where consortia on both sides, each one with about 6 different parties. So you can see the complexity that is coming, and therefore the disputes that are going to come, because expectations differ depending on cultural backgrounds. Scandinavians, in my experience, do not like compromise in mediation. They tend to say, we're right, and why should we compromise? Whereas, say, Koreans are brilliant in mediation. Koreans say, we may be right, but we want the job from that employer next time round, we'll compromise nevertheless. And because of those simple, stereotypical cultural differences, you get more and more disputes because of these complex consortia that are being set up all over the world all the time now.
Thank you. Perhaps, Robert, you're the right guy to answer this question as well. And that really is that, how is the world construction market changing insofar as the implementation strategy of their contracts is concerned? We're seeing the introduction of contracts like the ADC, which, obviously depending on which form, whether it's option A or one of the reimbursable type of forms of contracts, are supposed to be more collaborative contracts, and there's more involvement from the employer side. And I think that's one of the elements of the if you like, the initiative to go the adjudication route, where contracts are more collaborative. Now in South Africa, we've gone the other way. We have the ESCOM contracts, which are far more adversarial in their nature, and polarize the parties to the contract. One of my beliefs is that before we can really get our construction house in order, is we have to start working more collaboratively than adversarially. Less energy needs to be spent on fighting. Doesn't mean to say we're not going to have adjudications and those kinds of things, but where we're fighting over every element of a contract, that has to be counterproductive.
Yeah, I'd certainly like to hear the views of the rest of the panel on the local South African scene, which of course I'm ignorant of. But what I can say is worldwide, the FIDIC form is dominant, both for the civil engineering works, red form, and also for electrical and mechanical, yellow form. And even where, and this happens all the time, in many jurisdictions, you're appointed as arbitrator, first thing you do is look for the contract. When you get the contract, it's tinkered with FIDIC form, so that somebody sitting in Kazakhstan has taken FIDIC and tried to improve it. And never do that, is my experience. FIDIC is the product of long and hard negotiations from everybody in the industry, and people see it as fair. If you come along in North Korea or wherever you are as the employer and say, let's make this better for the employer, you make a minefield for yourself. I'll just give you one classic example. Most contracts allow for time extensions if the employer does something wrong, act of prevention. Some people have tried to, they look at it, they say, I'm the in-house lawyer for big employer. We don't want to give time extensions, even when we're wrong, so they delete it. And if you do that, somebody's already got it, times at large, because and there are hosts of Australian, UK, and goodness knows decisions which make that clear. You cannot simply allow a party to do what it likes without consequences. It doesn't work. And these contracts, like FIDIC, which have been negotiated over many years by all sorts of stakeholders, leave them alone. Just use them as they are. Don't try to improve them. You absolutely won't succeed, and you could make it blow up in your own face. But
I think it's a particular problem in this country where you have a number of, dominant is perhaps the wrong word, but a number of very influential and important employers, companies such as, or institutions such as ESCOM, Sasol and the like, where people are anxious for the work. And I find, certainly the contractors and the subcontractors, find themselves agreeing to particular conditions which are so onerous and take away from the fairness of the contracts where they're concerned, that it really ends up as a complete mess. And it often happens that these people come very short as a result of companies such as Eskom, Sasol, being able simply to say, take it or leave it. You don't like it, we'll give it to someone else. Bob, you must have seen it.
Yeah, but going back to your point, I've spent 20 years seeing disputes of every kind and recurrently. I think that South Africans are a fairly combative lot. We do tend to be confrontational.
Absolutely.
We don't settle things easily. I read a book called The Western Idea of Law, and I think it's exacerbated in this country. They point out that the Western idea is you confront. It's a confrontational system. In Eastern countries, they don't. Because in the East, they have a greater sense of community and a greater sense of ongoing relationships. So you want to keep the relationship. Here, we don't care. We batter each other, move away, and never see each other again. I believe that adjudication will do a lot to resolve that because it will be quick, immediate, and you don't allow time for these resentments and the bad blood to develop. They get dealt with as it arises quickly. People get, as I said, people like certainty. They know where they are. They might complain, but they don't like the decision, but they know where they are and they can start building their relationship and moving again. So I believe adjudication in this country in particular will play a very important role in reducing the tension that develops very often in long relationships.
So they might be equally unhappy, but at least they're still talking to one another.
That's correct. Yeah.
A question for the panel. When you're saying, and particularly to Robert from the UK experience, where you get adjudication or strategy adjudication that sets very tight deadlines, and you say the challenge against an adjudicator can easily be on lack of a fair hearing. What experience of that? Because if the time is short, and suddenly you get the defense comes in with a whole host of new arguments, maybe a counterclaim, but your time is up, and the adjudicator's got to jump in and do his stuff. What is the experience on that?
Yeah, well, under the UK system, the scheme allows 28 days, but 42 days if the referring party agrees. And of course, if both parties agree, you can have as long as you like. If the referral document is huge, and I mentioned 16 boxes, and for final account adjudications, that's what it's like. That is coming in from the referring party, and so immediately, certainly what I do is say, you can't do it in 28 days, I need 3 months just to have a stab at it. And I say, if I don't get 3 months, I resign. So I haven't spent any time on it, so I don't care if I resign because I'm not wasting any work. They know that if I resign, anyone else who takes it on is going to want 3 months also, because 25 boxes can't be done in 28 days. And if they were to find some idiot who did take it on for 28 days, the responding party would immediately say, we're going to object at the stage of enforcement because we won't have had a fair hearing. We can't deal with 25 boxes. And there is a lot of judicial support for that. There was a case that John Uff in Keating Chambers was the adjudicator on, and he said, give me 3 months, and I've looked at the referring party's documents. They're very complex, lots of arguments, lots of facts. And so the parties went to court to find out whether 3 months was the right answer. And the judge said, yeah, because if it's less than 3 months, the other party doesn't get a fair hearing, breach of rules of natural justice, and it would be unenforceable. So that's the answer. And so when adjudicators now ask for 3 months, they know they've got a very good chance of getting it.
Well, my comment was more aimed at when the responding party then replies and raises new defenses or a counterclaim.
Yeah. If that happens, of course, you're getting it later in the day. You've already done a lot of work. You don't want to resign. your immediate step is to say to the referring party, extend from 28 to 42 days. And he almost invariably will do that, because the last thing he wants is for the responding party to say, we weren't given a fair hearing because we had all these clever points and there were 2 days for the adjudicator to consider them, and that was inadequate. So you'll get the additional days for sure, and that gives you quite a lot of additional time.
Andy?
Yeah, but commonly then you get an application from the referring party, say, I want the opportunity to give a replication.
Quite right. I think really, it really comes back to the point which Guy was making just now. We're talking about, first of all, understanding the service that adjudication supplies to us, but also how we should use it. And it comes back to your point about the standing adjudication board. I think that the adjudication process is one of little and often. We don't want to have the onset of World War III before we start involving a third party into the resolution of the dispute. So you get the kind of scenario you're talking about, Andy. We should be able to deal with the principles early on, sort them out, give the guidance back to the stakeholders, as it were, and let them get on with it, rather than waiting to generate this almost a mini informal arbitration.
I feel I'm the only one who's ever answering, so do please kick in if you'd like to. What you're really raising here is the issue of dispute boards, which I was talking about earlier, where, as you know, dispute boards are an interesting phenomenon. Let me just say a little bit about their characteristics, because it determines how they behave. The average dispute board, in my experience, will consist of 2 engineers, each one appointed by one by the employer, one by the contractor. They appoint a third party, and the third party will be either a construction lawyer or a hybrid, somebody who's a construction lawyer and an engineer. But you'll have a lot of engineering expertise built in there. You'll also have the legal expertise as well. That group of people can add a lot of value to any project. These are not guys off the street. These are guys who will have spent their lives in the construction industry, be steeped in all the problems of the construction industry. So if you use them properly, and that's the standing board where they come to site every 4 months, they make very sensible suggestions. I've seen it happen. They resolve disputes in a very simple way, because they come up with simple ideas about testing or meeting and so on. And you also get very unexpected dynamics. Let me tell you about one I was doing in the Far East. We got this summons, because the thing about standing dispute boards is you can be called on at any moment. And we got the summons. Dreadful things are happening on site. You've got to come immediately. So the 3 of us dropped everything and we flew to site. We got to site and we were offered tea and everybody was very nice, and out came the biscuits. No one mentioned a dispute. So after we'd walked the site and we'd all come back and had some more tea, I said, right, you've just called us from London, Paris and somewhere else to site. Would you like to tell us about this dreadful dispute that's arisen? And they said, we've already resolved it. And we couldn't believe it. We weren't terribly happy, I have to say, because some of us had to juggle some diaries in a fairly major way. And I started chatting to them. And what became clear was these people were all working on a very isolated site. And they knew each other extremely well. I mean, these were people who every day were on site together in monsoon, heat, humidity, really tough conditions. They lived in the same accommodation, they worked together, they knew all about each other's wives and children. They were very close. And in families, you fall out now and then. and they'd fallen out. And instead of having a divorce, they phoned us. But of course, just as with families, they made it up. And then they realized these three total strangers, I mean, we came to site every 4 months, but we weren't part of the family. These three guys were going to come and start pontificating about the internal dynamics of their marriage on site. And they didn't want it. And so what they did was they promptly settled it so that they could throw us off site as soon as possible. Well, in fact, that was a wonderful outcome, because we didn't have to decide anything. We were able to go home as quickly as possible. They were happy. It was win-win. And I learned a lot about the dynamics of working on site in a very isolated place during the monsoon season.
I think that is an accepted benefit of having an appointed, whether it's a DAB or DRB or whatever it is, that you tend to work harder at settling your disputes and not resolving them, because it might be embarrassing.
Absolutely.
And putting out fires as they start, or even before they start, rather than letting them get out of control.
Yeah.
Absolutely. Yeah, that's it. Any other questions?
So, my name is Brian Westcott. I've just got a question for the panel. Would a court enforce an adjudicator's decision when it's an ex parte decision, where the respondents just refuse to participate? And put all this, I'm a big bully and it'll go to court and I'll probably go away. What is the experience in that?
No, I'm sure they would, but let me tell you that now there is the precise kind of case where a sussed adjudicator will protect himself. He will make sure that he's given this fellow every opportunity to come into it, so that the court will eventually say, this is just a fellow who's not cooperating. An inexperienced adjudicator will not guard himself carefully about it, because the adjudicator will know that is the vulnerability. He will guard against it. Of course, a court is going to enforce it. He says, listen, it's one thing you must hear him, but at least he must have something he wants to say to you first. If he doesn't want to talk to you, well, then obviously you don't have to hear him. But one has to just guard there against that, the possibility the court will say, no, you didn't give him a proper opportunity to be heard. There's no reason in principle why you wouldn't enforce it.
And equally, the person calling for the decision must make damn sure that the other party is given every opportunity of being there and is invited to take part fully. And if they then decide not to, well, then so be it.
I think the reality is that we see in this country, someone earlier was talking about the large and very influential employer bodies who use that as a tactic to try and either put a party off from going to adjudication for the sake of argument, and to delay the settlement and the resolution.
Robert, I'm Andrew Keelhack. I'm an advocate practicing at the Johannesburg Bar. We unfortunately have at this stage a somewhat dysfunctional court system in this country, where, for example, if we try and enforce an adjudication decision, the mere fact that your application to do so is opposed, in some divisions can lead to you waiting 8 or 9 months for the allocation of a court date for the hearing. I suspect that doesn't happen in the United Kingdom. If that did happen in the United Kingdom, do you think that your adjudication process would have been as successful as it's been if parties didn't know that there was a court with quick and sharp teeth to make the system work properly?
Yeah, that's an important point. What happens if you go to court but to try to get enforcement, but it's going to take you many months to actually get in front of the court? And that would totally undermine the good work that the whole process that I've been talking about has achieved. Certainly in the UK, enforcement proceedings come on very quickly. If it's important enough, you'll get it on in days, otherwise it might be a few weeks, but no question of many months. And that would defeat the purpose altogether. So, and if it had happened, I wouldn't be telling you the success story as I have done today. Good point.
Judge, do you want to make a comment there?
You know, I'm not quite as pessimistic about the court system as you are. And I must say again, for the last 15 years, I've been, sort of more remote from the hurly-burly of the high courts. But from what I read, and I mean, I read decisions from all the courts, delay seems to be a problem, I agree. But by and large, I don't think that one should be too pessimistic. It might be that one has to, try and go to the various courts, speak to them, get their buy into it, and all of these things might need to be done. It might be that the court system will not be as efficient. One doesn't really know until such time as the system starts unfolding. If it collapses because of that, well, that collapses because of that. But I think you can try it. And I don't think that you're going to have a problem. And I think that more people realize that their adjudicators are not going to be set aside, the less prospect you're going to have to use the courts. And that's why I emphasize in this country in particular, adjudicators must be really skilled, because there is the danger. And you want to expose them to the courts as little as possible. But the way the courts work is just not going to be able to control them. The only question is if you want to try adjudication and see if it works here. I think it will. I don't think the problem is, I think you might be overstating.
I'm more worried about squeezing payment out of a recalcitrant loser. Yeah. But maybe the first time the SCA says that enforcing an adjudicator's decision is inherently urgent, that might solve the problem.
Well, exactly. Choose a decision, you get a few decisions, as they did in England. They got a few strong decisions. Boom, that's it. Other courts will follow it. So I said, unfortunately, these cases don't get up to the appeal court very often. So there was that one case that we had. Well, we made a point, although it was not directly a point, of endorsing the system, as it were, at least. So the lower courts will see it's been endorsed. And you do need one case in which a debtor doesn't pay. Listen, Johannesburg's full of debtors that don't pay. That's what litigation is about here.
And in one way, your case has been quoted with gratitude.
But I think you've got the two processes running. The one in the enforcement of the adjudicator's award, and the other one is the arbitration to overturn the adjudicator's award. The chances are you're still going to get the court decision before you'll get the arbitrator's decision.
Now, just add something that one mustn't assume, and I'd ask Robert to tell me that. I don't think one must assume that each adjudicator's award is going to be contested. No, that everything, they're all going to be debts to be claimed. I suspect there are there are lots of genuine disputes in which the parties want a genuine resolution. They want to get on with their affairs. Yeah. So the enforcement is important, but one mustn't think, unless you've got an enforcement mechanism, none of it will work.
On this point of enforcement, the proposed draft regulations have incorporated a different spin than the other regulations and similar statutes. And that is that there's a proposal in these drafts that an adjudicator's award, by operation of statute, becomes a liquid document, and also an entitlement to proceed directly to provisional sentence. Is that something that could work? I've got a view that perhaps a bit pessimistic of it, but put it to the panel.
I don't know what Guy thinks. I don't think it's necessary myself. It goes back to the point of, can you get a court? If you can take an adjudicator's award to a court and you can get a court to hear it, you don't need provisional sentences, liquid documents, you get summary judgment. There it is. You just need the court. I don't think there's anything wrong with the processes we've got to enforce an adjudicator's. It's just a contractual undertaking that you pay, you pay. That's all there is to it.
Yeah, I agree entirely. Provisional sentence is problematic at the best of times, and provided you've got strong courts that will give summary judgment in these circumstances, I don't think you do need it.
Thank you. Any other questions?
One more. Someone else?
I'm Tony Penfold. The current proposals are that the mining industry is going to be exempted from this legislation. The mining industry is one of the major employers and major industries in the country, and secondly, The mining houses are notoriously some of the biggest bullies as well, as we all know. Consequently, if they are excluded, are we going to actually manage to make this work?
I think it comes back to this question of getting them to buy in. The moment you get big players in the industry who are not prepared to get involved, in the absence of legislation, it's not going to work.
I think my observation would be a equally pessimistic view of the mining industry and the possibility of work out of the mining industry or construction work out of the mining industry in Southern Africa or South Africa anyway. I don't hold out huge hopes for that. You'll know better, Tony, than I do, but I'm not hanging my hat on that work coming.
But Robert, may I ask you, as I understood your talk, it was that it works there because people see it as being advantageous. Absolutely. And even the mining companies, I'm sure, if they saw it as advantageous, they would adopt it. Not because they're being forced to, but because it's advantageous. If it's not advantageous, they won't do it. Same as all of you guys won't.
Yeah, I mean, nothing succeeds like success. And I mentioned how power stations and process plants got exempted initially because we asked for it because we thought this was a silly process. Everyone saw it was a huge success. Everyone wanted quick decisions, cheaply, that you could get on and live your lives thereafter. And so everyone now uses them in the way I described. So maybe the mining houses will see the light and do that.
Andy again.
Yeah. How do you feel that a process such as a FIDIC DAB would fit in an environment where you have statutory adjudication?
Yeah, I don't see any particular problem there. The statutory adjudication is there, but the FIDIC DAB's got those two quite distinct functions that I mentioned. If the FIDIC DAB is doing its job properly, you may never have a dispute that needs to be adjudicated because it'll be resolving things in this very informal way as I've described. Only if an adjudication actually crystallizes and has to be dealt with does all the legislation and the scheme need to be taken into account. So it may or may not ever be used on a project. And in my experience, you can have a pretty good shot at totally avoiding adjudications altogether.
I understand that, say, the Australians have grappled with this problem and then almost have a step of a DAB contractual adjudication before they mobilize the statutory adjudication.
Yeah, I'm not aware of anything like that happening in the UK. As I say, first objective is to avoid the adjudication ever happening. And if it does, you know, everyone in the construction industry in the UK now is so familiar with all the requirements of the Act or Acts and the scheme. And so when an adjudication's got to be dealt with, everyone knows what to do, and we all do it. That's what applies.
Any other questions?
Perry Zagarita, do we know the timing of this amendment to the Act?
We expected it 3 years ago. We still don't know.
We expected the new Arbitration Act.
Was it 65? We've been waiting patiently.
But I don't think you need to wait. That's the point. I don't think you need to wait. In fact, what is happening in England, just through osmosis, is going to be upheld by the courts here.
Well, I buy into what you're saying, Judge. I honestly think that the construction industry, for too long, has just followed or played follow my leader. We need, as an industry, to take things into our own hands and move forward, regardless of what the government does, regardless of what the unions say, or regardless of what anybody says. We must do the right thing, not what somebody else tells us to do.
The benefit of the Act will be to stop those, we say, bully employers who actually delete the FIDIC
clause related to DAB or the NEC adjudication provisions. They just put a line through it and say, if you dislike the decision, take me to court.
Why blame the bullying employers? Why not talk about the attorneys that draw up the contracts? Any other questions?
Hi, I'm Lucia. I've got one question for the panel. Is there an established set of skills for adjudicators as opposed to arbitrators and mediators?
In my experience, the most popular adjudicators in the UK are quantity surveyors, because most disputes are simple, straightforward. You're holding a small sum of money which you should give me, and a QS is the ideal person to deal with it. So the Royal Institute of Chartered Surveyors, the RICS, is by far the biggest appointing body. That's where people go, and they appoint, to a very large extent, quantity surveyors. They have a few other people on their books, but quantity surveyors are handling the vast bulk of work. When you get into the more complex cases, then they tend to come to construction lawyers, because there's going to be a big legal element, and you've got to get it right, because otherwise ultimately some arbitrator can attack you. But small stuff, all quantity surveyors. Intermediate stuff, some quantity surveyors, some lawyers, and the big stuff is almost all lawyers.
I'm sure that's not the answer you wanted. What you wanted to hear was anybody who's been on the MDA course.
Just in terms of the standard of proof required, if there is any, what difference, if anything, in the panel's experience, is that standard between the submission that would be made to an engineer at claim stage and then to a DAB constituted in the FIDIC environment? Should there be any difference? Is there any difference in the panel's experience?
I don't think there should be any difference. But at the end of the day, it's a value judgment that you apply, and you do this to the best of your ability. And the safeguard, of course, is that a DAB's decision is subject to arbitration. Yes, it's immediately enforceable. If there is an award by a DAB, it's enforceable immediately. But there's always the safeguard of arbitration, and being a quick and robust process, perhaps at times you don't go into the nuts and bolts of the dispute as adequately as you would if you were in an arbitration. But it ought to be a quick and fairly robust decision that's come to quickly, and you do this to the best of your ability.
Contractually, I don't think the problem arises, because the standard of proof arises in adversarial proceedings, in which the arbitrator or judge sits and he says, okay, you prove this, and you prove that. An adjudicator has got power to go in himself, and he says, I want those. He can find the truth himself. It's not dependent upon what proof is provided to him. He finds the truth. Would I be right on that?
That's exactly right. Yeah.
Thank you.
Any other questions? Okay.
Good afternoon, Alain Jacquet. I'd just like to inquire a bit about the experience, especially in the UK, around the value or the complexity around adjudications. We've been talking about very large projects, we've been talking about millions under dispute, but adjudication is also applicable to very small disputes. What is the kind of distribution that you're looking at? Is it right throughout the range? And this is something that we need to maybe consider in South Africa. Small disputes can be also looked at by adjudication rather than waiting for a very big problem to arise.
Yeah, you're absolutely right that there is this complete range, and the vast bulk of adjudications in the UK are for small amounts. 25,000 here, 15,000 there, and that's where these QSs are coming to their own, because they can look at the documents, if necessary, go to site, and make a decision, satisfy the 28 days, charge a fairly modest amount because they've spent very little time on it, and everybody's happy. But you get, as you pointed out, a huge range from that all the way through to, I've certainly had, here's a £10 million final account claim, and all the boxes come to along with it. And it's not what adjudication was ever meant for, but there are some of those around. But the vast bulk are the small ones.
Any other questions?
Yeah, I've got one. Are we currently experiencing client bodies not taking accountability, and that's the reason why they sometimes take the dispute route, so that they, and it's major client bodies, so that they're not held responsible for the decision on the ruling? Did you experience that in the UK?
Local authorities in the UK are proverbial for exactly that. The perception is all the guys want to do is cover their backs, and they absolutely don't want to make a decision because the decision might be criticised. But if some judge or arbitrator or adjudicator or whoever makes the decision, that's fine. They didn't make it, and they're not accountable for it. And so where I find that a problem is in mediation, because in mediation you've got to have somebody who will make a decision. And local authorities are really difficult in mediation. And the way we've got around it now is you get to something which is crying out to be settled, and then the guys attending from the local authority will say, we will take it away and recommend that there be a settlement on that basis. And you always get the settlement thereafter. But adjudication doesn't suffer from that particular problem because they're happy for it to go in front of the adjudicator. He makes the decision, they don't, and everybody's happy.
Yeah, there's comments made to such a degree that the tender board is more accepting on an adjudicator or a mediator's ruling than if they propose the settlement. That's
Yeah, well, as I say, if somebody wants to avoid making a decision, then going to any sort of tribunal is fine, and that includes an adjudicator. Mediation doesn't have that because somebody's got to make a decision within the team itself, and they won't do that.
They've got to have willing settlers, haven't you?
You've got to have willing settlers, yeah.
It's one of the very first things that you, as a mediator, you do insist upon is that someone who can sign a settlement agreement must attend the mediation.
Yeah, absolutely. Yeah. Any other questions? Okay, well.
If there are not, may I ask a question of that gentleman?
Please.
You said that employers would, bullied employers would take out the clauses. Why would they take out the clauses? Why do they take out the? Would they take out a clause on adjudication?
I've seen.
And why would they take it out?
I've seen a large employer take the FIDIC clause 20 out of it and actually go back to the old engineer's decision that was in the old FIDIC forms. And if you're not happy with the engineer's decision, you go to court. So then, I've seen that in contracts.
But obviously that's a case where the employer has not seen that there's advantage to him in it. So if you persuade him, and if he sees advantage to himself, he won't take it out.
Yeah, and I've seen quite a few of what Robert said. I'm very pleased to hear him say about the dispute board, dispute avoidance provisions, which is even stronger in the pink book. Anyway, they delete that and they just say, if we have a dispute, because we don't believe there'll ever be one, if we have a dispute, then we'll wheel the dispute board in. And that's extremely tempting for employers.
Well, until they bought into the system and seen that it is advantageous, and they will then leave it in.
I won't name the employer that deleted them here, but you'll know who it is.
Just make sure some of them are here next year so they can learn about the advantages.
Thank you, Wesley Suter. I work for an employer's body in this ongoing issue, obviously, with trying to talk to employers about the issue. Excuse me. Obviously, if you talk to them about it and get them all together, it's a bit of a competition issue, and I think it sort of proves the issue everyone's speaking about the need for legislation. Otherwise, they won't be agreeing to keep any stand in terms of contract anytime soon. I'm not sure if Uber wants to comment about the JBCC.
We've got that problem all the time, unfortunately. And maybe an anecdote, which is not our contract, but it doesn't matter. I came across a legal advisor for one of the major state-owned companies. We had lunch together. He used to work for Eskom. And as you know, FedEx is used by Eskom, and a firm of lawyers who shall remain nameless added 50-odd pages to that FedEx agreement. And in the words of this legal advisor, that is 3/4 of the problem, apart from the political side. And we've got the same problem. We've got the same problem with subcontractors. And this week alone, I've had 8 questions from subcontractors who are not getting paid. And I said, what contract have you got? What have you signed? I don't have it. Where do I get it from?
Yeah, I think we all accept that there's a huge amount of adjudication across the board, not only about adjudication, but about the whole administration of our contracts and how we go about those things. Absolutely. Any other questions?
If I would add on that point, I think with the deletion, the main reason it's deleted as well is because the clients and their advisors don't understand what the adjudication or dispute board process is. So therefore, because I don't understand it, let's delete it and stick with what we know, which is arbitration.
Well, we delete anything that might make it look easier for the contractors. Is that the way it works?
Less pages for us to read.
Any more questions? Chris?
Yeah, just one point. I know Justice Nugent is perfectly correct. Adjudication operates very well at this stage. The problem is sort of the broad psyche of society. If you look at the impact of another act totally unrelated, like the Consumer Protection Act, a lot of what was in there was basically just protecting the common law position from abuse by financial institutions. Now, and also it starts a new level of consumer activism. People know their rights all of a sudden. Most people had no idea they had any chance against these guys. And now by putting in an act, by saying, yeah, we have compulsory adjudication, you can't, Mr. Big Employer, force me to go to litigation because you know it's going to take me 10 years and I can't possibly afford it. And to back up Robert Gaitskell's point, the vast majority are going to be small. I think once you pass the legislation, you'll most likely see a deluge of adjudications from little guys. About 80% will come from the small guys, particularly working for local authorities, who I think, if I heard correctly the other day, are trying to stall this pay when paid and all these prompt payment provisions because they just can't do it. So I think the benefit of legislation is more than just making adjudication work, it's actually industry-wide, of a much greater import in creating a sort of activist, subcontractor, and contractor level that previously wasn't there.
Look, don't get me wrong, I don't suggest that we should not have the legislation. I just don't have a great faith in the speed at which legislation gets through the parliament in this country. And all I caution you about is I don't think you should sit back and say, okay, well, there's nothing to be done until there's legislation. I think, you see, the point about the legislation, the guys, I can't see any reason why any employer would take out this clause, other than one employer. And that is one who's decided in advance he's not going to pay his contractor and his subcontractors and so on. That's why you would take that. But apart from that, if he is a genuine employer who wants this contract done properly, and he wants to get to go smoothly, and he wants disputes to be resolved properly, there is no reason to take it out. The only guy who'll take it out is the guy who doesn't want to pay. Well, okay, that's some of them. So the legislation is needed for that. I hope that is not the majority of contracts in this country. Well, at least not the vast majority. I hope there are some contracts in which there is good faith between the parties.
Yeah. Any other questions? Ladies and gentlemen, thank you very much indeed. The gentleman of the panel, Dutch, you, Robert, thank you very much indeed. Thank you.